Good afternoon, everyone. Welcome to session 14 of the Delhi State Legal Services Authority Learning Series. The topic for today, recording of evidence, affidavits, exhibits, and objections. We all know that this is the core of the court functioning. Recording of evidence, if you take mastery over this subject, then the trial is completely in your hands and how to make sure that the trial results into the fair justice. To share with you this aim and vision of this topic with all the legal aid lawyers, I would now request our member secretary, Shri Kavaljeet Arora ji, to take over. Over to you, sir. 1 second, sir. I think, yeah. Yes, sir.
Thank you, Shreya.
Right.
Madam Neena Krishna Bansal ji, Learned District and Session Judge, Southeast District Saket Courts, Learned Secretaries of District Legal Services Authorities, and dear panel lawyers of Delhi State Legal Service Authority. A very good afternoon to all of you. So friends, as promised, we are back again with you with the double header of this week, which we had dedicated to recording of evidence only. On Wednesday, friends, in the last session of this learning series, we had learned the art of cross-examination. So today we are here and we will enrich ourselves on recording of evidence as such, tendering evidence by way of affidavits, marking exhibits, and raising of objections. This is a very crucial topic, and there is a lot of say confusion about this, that whether affidavit once filed, how it is to be tendered, how exhibits are to be marked, and how objections and what objections should be raised. And friends, what we see is that why evidence is very essential and material in any trial, be it civil or criminal. I'll say that every trial, whether it is civil or criminal, it is basically a voyage, quest of which is always the discovery of truth. So the onerous duty which is cast on any court of law is to subserve the ends of justice by arriving at the truth. Judicial scrutiny of facts proved by admissible piece of evidence culminating into a reasoned judgment is an integral part of any trial. So any court of law, without having the evidence on record, and evidence, I'll say that admissible evidence on record, cannot arrive at its culmination, cannot arrive at its final conclusion, and that is what is necessary, what is the most integral and necessary part of trial. Friends, we all know that in a civil case, the onus to prove is always on the party who alleges or claims regarding existence of a particular fact, and this onus generally shifts also depending upon the facts and circumstances of the case, and parties, they have to establish their respective cases so far as civil cases are concerned on the basis of preponderance of probabilities. This we all know. And if we compare it to the criminal trial, in a criminal trial, the onus to prove, that is always on the prosecution, which needs to prove the same beyond reasonable doubt, and it never shifts. Yes, of course, there are certain special laws where, like PC Act is there, where there is a presumption, and the criminal court in that matter dealing with Prevention of Corruption Act can take assistance of that presumption. So having said that, we need to ponder as to how a particular fact which is claimed before the court by the parties is proved. So friends, we have our Indian Evidence Act. For proving a fact, evidence is required to be adduced. Section 3 of Indian Evidence Act that regulates the production of evidence, which may be oral or documentary. अगर हम एविडेंस एक्ट के सारे प्रोविजंस को अगर हम देखते हैं, पढ़ते हैं, दे आर गिवन इन अ से वेरी साइंटिफिक मैनर. अगर हम उसको जाते हैं, देखते हैं, एंड we find that various provisions of Indian Evidence Act, the idea of best evidence, that is very much implicit therein, though it is not mentioned anywhere, but the idea that best evidence is to be adduced is implicit in all the provisions of Evidence Act. Best oral evidence is of course of a person who has actually perceived something by that sense by which it is or was capable of being perceived. Section 60 of the Evidence Act, it deals with it. So far as documentary evidence is concerned, Section 3 of Evidence Act deals with documentary evidence as well. Document means any matter expressed or described upon any substance, चाहे वो paper हो सकता है, कोई piece of cloth हो सकता है, anything on a piece of substance by means of any letters, figures or marks, or by more than all these means intended to be used or which may be used for recording of that matter. That covers the definition of document. And genuineness of a document, that is generally proved as per Section 59 of the Act, and the contents of the documents are proved by way of that primary evidence, which is that document itself. That document can be a piece of paper also, it can be a digital document also. And when we prove a digital document, then Section 65B comes into picture. Friends, when you act as a counsel for the person whom you are assigned a case by District Legal Services Authority, various questions I'm sure that comes to your mind while recording of evidence, because that evidence is very material. As I said, these questions can be that in case you are dealing with a civil matter, or for that matter in criminal cases also, that how the handwriting or signatures on a document are to be proved, or how secondary evidence assumes importance in absence of primary evidence. Then there are certain questions regarding role and opinion of expert, that what is the role and opinion of expert, and how much relevancy and admissibility and credence has to be given with respect to the opinion of the expert, either with respect to handwriting or with respect to signatures. Then whether exhibiting of a particular document in itself means proof of it. You must have seen in your say tenure while working as defense counsel or while appearing for the complainant, that if a particular document has been exhibited, that will that mean that no further evidence is required? Merely exhibition of the document in itself, whether it means that document stands proved in court of law, its admissibility is to that extent that court will take that into consideration without anything further. Or there are other questions, that how a public document is proved and what is the admissibility of that document. Then what is the procedure and mode of recording of evidence. Now, whether filing of affidavit is sufficient, or whether the same is required to be formally tendered by the witness who has deposed the same. Then whether evidence can be recorded through court commissioner, and if yes, what should be the language of that evidence. Then there are certain questions which generally comes to our mind, or which are generally raised in the court during the course of trial, that how many opportunities need to be granted to the adverse party for cross-examination. That is, after how many opportunities court should close the further opportunity for cross-examination. If a party takes, say, 2, 3, 4 adjournments, then what is the leeway with the court that it should not grant any further opportunity and proceed ahead with the, say, rest of the trial. So how the exhibits are to be marked on the document. Then can the party, while tendering evidence, go beyond the pleadings or beyond the issues which are framed for the purposes of leading evidence. Then how the objections are to be raised before the court of law. What sort of objection, when should we raise the objection? When the other party, other counsel is doing something or raising or putting a particular question to your witness, then how objections are to be raised. Now, whether these objections they need to be decided then and there, or can we proceed further? Can the court proceed further for recording of the evidence and decide these objections at a later stage? So whether the precautions, what are the necessary precautions which are necessary while recording the testimony of a child witness or that of a vulnerable witness, day in and day out, we see that in rape matters, POXO matters, there are certain vulnerable witnesses, how their testimony is to be recorded. So these are very material questions. These are very pertinent questions which erupts quite frequently while recording of evidence in a court of law, where you appear for the purposes of, say, defending, or for, complainant, whosoever is assigned to you for performing your duty as legal aid counsel. So as evidence and recording of it is the most crucial part, as I said, in part of administration of justice system, because without evidence on record, no court would be in a position to arrive at the final conclusion. Therefore, we must need to find out the answers to all these questions, which generally erupts, which comes to our mind, which are generally raised in a court of law. So I'll say that to help us in this regard, we are fortunate to have with us Madam Neena Krishna Bansal, learned district and session judge, South East District. She has the judicial experience of almost 3 decades now, and during this tenure of 3 decades, she has presided over different courts dealing with civil and criminal jurisdictions. She had also been director of Delhi Judicial Academy, where she had been, say, grooming the new judicial officers also. And she had been organizing seminars for all of us, for refreshing our memory and apprising us of the new laws which are developed, or say new judgments which comes on different propositions of law. So I'm sure that we would all benefit from the talk of hers, wherein she would encapsulate her entire experience and expertise. Thank you, madam, for accepting our request for this session. So without taking any further time, I would request Shreya to formally introduce learned eminent speaker to our audience. So over to you, Shreya. Thank you.
Thank you, sir. So, our member secretary has already shared with all of us that ma'am has her expertise, and she has been the director of Delhi Judicial Academy for a long time, and she has been teaching development of law to many judges. So now we are really privileged that she's today here with us for our legal aid lawyers. Our resource person, ma'am, joined judiciary in the year 1992, and she's held a lot of courts, including as a metropolitan magistrate, civil court. In 2003, she was promoted to Delhi Higher Judicial Service. Post that, she has been as stated, she has been with Delhi Judicial Academy. She has also been director of Delhi Dispute Resolution Society, and she is the one who was behind the setting up of the Delhi Dispute Resolution Society, the mediation center of the Delhi government. And she has also been posted at National Human Rights Commission, NHRC. In court sittings of her include family court, POXO court, and she's here with us all today to discuss on this most important topic, the recording of evidence. We are indeed privileged to have her here, and I would request our learned resource person to now take over. One second. One second.
Good afternoon, Shreya. Thank you so much for handing over this screen. Formal good afternoon to Kamaljeet, our Member Secretary, Delhi State Legal Services Authority, Shreya, and all other secretaries of the District Legal Services Authority. It is a matter of, and of course, the panel lawyers who are the main, I would say, our resource persons, because they are the ones who are going to feed us with questions and make us move forward in our learning. Dear friends, it's a great opportunity for me to be invited today by Dslsa for this talk. I must acknowledge and thank Kamaljeet, who has tirelessly been working since he took over as the member secretary in last 1 year, and he's been doubly so working after the COVID outbreak. There has been a situation created by COVID, and but it is said that every situation, every happening, every incident has a new opportunity and a new challenge. What is required is that we identify, we recognize, we perceive the opportunity and work it to our advantage. Realizing that COVID outbreak is going to immobilize us for some time, Dslsa decided to utilize this period for capacity building of all the stakeholders. And therefore, I've designed these learning series to on the topics most relevant for our stakeholders, and they would help us to not only enhance the knowledge but also hone the skills of advocacy. Once again, I place my acknowledgement formally and thanks to Dslsa and especially to Kamaljeet for inviting me on this today for this subject. When I was asked to address, I went back to my college days. That was about 35 years back, a long time ago. At that time, law was not taken by choice. What I said, people took admission more by way of default. When they did not get their admission either in their so-called quote unquote professional courses like medicine, engineering, CA, this is where everybody found themselves landing. The reasons were very interesting. The many who joined law were because they wanted an hostel accommodation. There were some who wanted the use of library because they were all preparing for their civil services. I think the biggest advantage that we had was of DTC pass, which was very important. With that 1250 rupee pass, we could travel anywhere in Delhi in DTC buses, which used to be a big attraction. But when I talk of my times, I am reminded of a conversation which happened between the Cheshire Cat and Alice in a very famous book, Alice in Wonderland. I'm sure all of you would have read or heard this story of this girl who wandered into Wonderland, and when she was lost, she reached a road which bifurcated. She did not know where to go, and then she looked around and she found one cat whose name was Cheshire sitting on one of the branches of the tree above. The quality about Cheshire cat was that she could rotate her neck 360 degrees. This means that she had a 360-degree vision. What was written in 60s is now being followed, that when we do any work or take up any project, we all must have a 360-degree vision. That is what Cheshire cat had. So Alice asked the cat, "Would you tell me, please, which way I ought to go from here?" The cat said, "It depends a great deal on where you want to go." "I don't know," said Alice. Prompt came the response, "Then it doesn't matter which way you go." But Alice had to explain herself. So she says, "So long as I get somewhere." And the answer was, "Oh, you are sure to do that if only you would walk long enough. If you do not know the path that you want to follow, if you do not know where you want to go, this is what happens. It really doesn't matter. You can keep trying. The only thing is, it will take you a long, long time to actually reach where you wanted to reach." In our times, about 50% of the students who took admission in law would drop out. Many would leave after completing their law. Very few people joined law as a profession. There was that kind of respect for the profession. But in the last 15-20 years, there has been a tremendous change in our attitude towards this profession. Since it has become a 5-year course and there is an entrance exam required to take the admission, people have started taking it as seriously. Now, it is not as if by default you end up in law. It is a conscious decision taken by all of you to pursue it as a career. This is what Robert Frost had to say. "Two roads diverged in a wood, and I took the one less traveled by, and that has made all the difference." When you all have chosen law as a profession, it has been a choice, and I'm sure our endeavor here is to become the best in the profession. Every one of us is giving 100%, and everyone is doing very well. Yet, there is no limit to knowledge. There is no limit to saying that I have become an expert. It is only by more learning by more practice that we can acquire we can achieve new heights in this profession. Now, to be a good lawyer, what are the two qualities that we look for? Of course, knowledge, to which there cannot be any uh, alternate. One has to acquire knowledge, which starts the day you take admission in law. But what is required more than law is what I will try to tell from a story. When King Simon was crowned, he had the big feet, big shoes of his father to fill, who had been an extremely competent and a good uh, king. So he prayed to God, and the God came and he said, "What is it that you wish for?" He said, "Wisdom I would acquire with passage of time, knowledge I would learn, but I pray that please give me a whispering heart." Now, what is this whispering heart? It is nothing but compassion. It is only when you are full of compassion, you can understand, you empathize with the clients who come to you, that would make you an absolute, a complete advocate. So, what I have experienced, what I have felt, that no matter how knowledgeable you may be, but unless you are also humane, you are compassionate, all your competence would be lost. What I recommend thus is that there should be a lot of compassion with competence. If we are able to acquire both, that is what will make us from a good lawyer to a great lawyer. And that is what our endeavor should be. Now, when we talk of this, what we need to, we as Kamaljeet had flagged earlier, there is knowledge of law, which we have acquired in college, and we have also been practicing. But what will be more important is the skill of advocacy, the law of evidence. How is it to be applied in the court? I think Kavaljeet has given a very good background of what all recording of evidence entails. Under the law, there are three branches. There are three branches. One is substantive law, which we all understand defines the substantive rights, like IPC, which defines what the offences are, or contract or DPA. These are the substantive laws which give under which you get your rights. How are we to agitate these rights is defined by procedural laws. That is our Code of Civil Procedure and our Criminal Procedure Code. But are these two in itself enough? We know the procedure, but how is it to be actually applied when we are trying a case is defined by evidence law, which is also known as adjective law. It is this law which helps us in implementing and executing the procedures that have been defined in CPC to achieve the substantive rights which are defined in different statutes. How do we do this? When we see a trial, what do we think is most important in a trial? Of course, the law. But is it the primary requirement? No. What is most important is that the facts, it is the facts which are jumbled up, which are lost, which are confused. During the trial, it is the first and primary job for us to sift out and to place the correct facts on record. It is only when the facts have been clearly established that the law can be applied. If no matter how strong our case may be under law, but if we are not presenting it well, if we are not putting the complete and correct facts on record, the whole exercise would be lost. There are times when we feel that we had a good case, but why is it that it has gone against us? Largely because we have not presented the facts correctly. And this is where the significance and importance of our evidence law comes in. CPC would say that you have to produce the evidence, but how is it to be presented? What all it should contain and how it should be exhibited is what is defined under the Indian Evidence Act. Can I now request if we can have our PPT, Shreya? Shreya?
PPT is there.
Your PPT is there?
To the slideshow.
Right. Just give me a second. As was said in the beginning, what is our endeavor as a judge? Our motto is Satyamev Jayate. That is, truth alone triumphs. And for truth to triumph, the true facts have to be brought on record. There are, under the Indian Evidence Act, there are certain basic conditions which are required to be established about the facts. The first most important thing is it should be relevant to the case that we are trying to present. The second thing is it should be material. Even if it is relevant, it is material. The third condition, which is very important, is that it should be admissible under the Indian Evidence Act. And what are the factors which go to the admissibility, as was flagged earlier? Whether it is primary evidence, whether it is secondary evidence, whether it is documentary evidence, and the basic rule of leading any evidence is that the best evidence has to be brought on record. If a document exists, its contents cannot be proved by oral evidence. And yet there are certain facts which are not documented. And in those cases, it is the oral evidence which becomes most important. Connected to these is another factor, and that is the authenticity of a document, whether it is a real, genuine document or is it a forged document. It is extremely important to, even because I'm sure during the trials there would have been many a times when you would have felt that a document has been produced, but it may not be authentic. Recently, I was doing a civil case where an original letter was produced, but on the face of it, you could make out that it is a forged document and therefore had no admissibility under law. Connected to this, I would have loved to pose this question to you, that in India, is the evidence which is procured by poisonous means admissible in law? When I say that, whether any statement obtained by torture, is it admissible? The answer, of course, is no, because it is prohibited under law. But what if a document has been procured by unauthorized means? There have been times when the notings of the files have been obtained from the government or from the office, from the records, which is not accessible to public. Are we going to exclude that evidence? As Indian law stands, such evidence, so long as it is relevant, it is material, it is genuine, it is admissible, even though the way in which it has been procured may not have been absolutely above board. Now, again, we had discussed in the beginning that the evidence can be oral, that is, it is a living proof and is known as probatio viva. The other kind of evidence that may be there is documentary. As initially Kamalji pointed out, anything which is written on a substance, which may be paper or tree, so long as it is a written, marked, or is signed, it becomes a document. Now, in document also, there are two different kinds of documents. One is demonstrative, like site plan, photographs, etc. The other evidence is real evidence. Now, what do we mean by real evidence? Real evidence means the objects that become a subject matter of a dispute, like a knife, a gun, a car, or any other such instrument which is a real object. These are known as real evidence. One must understand that documentary evidence can be of two types. One can be the document, demonstrative, and the other is the real or the objects which are relevant while we are doing a trial. This kind of documentary evidence has been termed as dead proof or probatio mortua. Now, I'll come straight to the point. Evidence law is tremendous. We can spend weeks and months and years on understanding this small act, but I would confine myself today strictly to the topic that we have in hand. Our evidence is largely in the court by way of the witnesses who come to depose, that is oral witnesses, and the second is the documentary evidence, which is tendered by way of affidavit and the documents which are appended thereto. Now, these documents are tendered in the court at two stages. The first stage is at the stage of admission denial, and second is when it is tendered in evidence. When tendering a document for exhibiting, there are certain prerequisites. There are certain aspects which must be taken care of. First is you must lay a foundation. You must, that is done by way of oral evidence. It is explained why a document is being produced in support of which evidence the said document is being produced. The second is one needs to prove the custody or the source from which the said document is coming. And third, of course, as we flagged, it has to be best evidence rule. The document in original is the best evidence. However, there are certain documents which are per se admissible, like public documents or the documents which are 30-year old, to which we'll come later. Now, in my experience, when I've been working in the court, I have found that there is a great confusion of how the documents have to be numbered and exhibited. Many a times the affidavits are tendered wherein the documents are exhibited, but when it comes to formally tendering it in the court, some of those documents are missing, or some are photocopies, or are otherwise inadmissible. The confusion occurs at this stage because when the exhibits are being put or the documents are being marked and an objection is taken or a document is found to be marked which cannot be taken on record, tendency is to renumber the exhibits. So the exhibits put on the document do not correspond to what has been put in the affidavit of evidence. Here, my request is that if there is, suppose a document PW1 over B, which needs to be taken off, simply record while tendering, it is de-exhibited and marked or whatever be the case, but never renumber it in the evidence. Whatever is the numbering of the documents in the affidavit should correspond to what is being recorded in the court. Now, how do we put an exhibit? That is defined under Order 13 Rule 4. Each document must have the number and title of the suit, the name of the person who is producing the document, the date on which it is produced, and the endorsement under the exhibit has to be signed or initialed along with the date by the judge. Another challenge which I have found many a times in the court is that the documents are handed over across the counter without there being any list of documents. Filing a list of documents along with the documents is one of the most important aspects. Why? Because at the stage of appreciation of evidence, at the stage of final arguments, many a times you want to see which party has filed a document. But that we cannot ascertain because there is no list of documents that has been filed. It becomes even more important because if a document has been filed by a party and even if it is not proved, that document can be read in evidence against the person who has placed it on record. All these benefits go missing if there is no list of document filed along with the documents. My request is that when a document is being tendered at any stage, whether it is at the stage of admission denial or it is at the stage of evidence, it must always be accompanied with a list of documents specifying the party who is tendering, the date on which it is being tendered, and the name of the party or of the counsel clearly mentioned. Merely putting a signature may not be a good idea. Now, how the exhibits are to be put, there is lot of different practices which are being followed. This was taken up in a celebrated judgment of Sundhir Engineering, where it was explained how the exhibits must be put. When it is being done at the stage of admission denial, then it is to be exhibited as B1, B2 or D1, D2 when it is being done by the defendant. Once this kind of an exhibit is put, one knows that it is an admitted document and no further evidence is required on that document. If it is being tendered in evidence and it is being properly proved, then it is marked as exhibit PW1/1, PW2/1, or DW1/1, DW2/1, as the case may be. One point to be noted is it should be done numerically. It is not the alphabet, but 1, 2, 3, 4, which should be generally followed when we are exhibiting documents in our affidavit. Now, there are certain documents to which an objection is taken, like a photocopy, or when there is no foundation for leading secondary evidence. Those are the documents which we are traditionally marking as mark. When we are putting a mark, then it has to be an alphabet. Mark A, mark B, and so on and so forth. Then it is not numerically done, but it is done through alphabets. Here there is a rider which I would like to highlight. This is that merely putting an exhibit or a mark is for the purpose of identification, and it need not necessarily mean that a fact stands proved and it has to be read as such in evidence. Now, when we are exhibiting a document and it is put as PW1/1 or DW1/1, when do we do it? When it is admitted, when the formal proof has been dispensed with, when it is a certified copy of any judgment or record of the court, it is a 30-year-old document, or it has been proved by judicial evidence. Here I would like to add a rider. There are many a times when the pleadings, the certified copies of the pleadings are being tendered, they may be exhibited if not objected to, or if the other party does not want a formal proof. But pleadings are a private document. These are not public documents. In case any objection is taken by the other party, then it is the original record which has to be summoned, and then the certified copies exhibited after looking at the original records. Now, once a document has been exhibited without an objection, its admissibility cannot be questioned at a later stage on the question of it not having been proved according to the true procedure. Of course, there is a rider and exception which we must remember, and that is it is inadmissible if because of some statutory bar or non-compliance of statutory requirement, the document is made inadmissible by law. The second category, of course, as we discussed, were the marked documents, which is done generally by alphabets. Another thing which is very important here to note is that every document must be identified. Now, how do we, if there is a, suppose a rent agreement which runs into 7 pages, by saying exhibit PW1/1 is not sufficient, but it should be PW1/1 to 5, so that the number of pages are also indicated. This way, while we are writing a judgment, if suppose I have to refer to page 3 of the agreement to sell, I should be able to identify it correctly. These marked documents indicate that they have not been proved as per law, and they are required to be proved further, and these documents would not be read in evidence. There is a third category of documents, which is when an exhibit is put, but it is recorded objected to on the request of the other party. It means that the question of inadmissibility has been kept open to be decided at the later stage or at the time of final arguments. Marking or exhibiting of a document is provisional or tentative, and is subject to the rules of evidence. Now there is this third category of real evidence, and that is like objects, weapons, vehicles which come up for trial. These have to be exhibited as P1, P2, P3. As a practice, I have always been writing PW1 over P1 to indicate that it is in the testimony of PW1 that the object has been exhibited. What happens is, if it is only P1, P2, P3, then in the second witness also, the objects get identified as P1, 2, 3. There is duplication and there is some kind of confusion because there would be many objects which will be exhibited as P1. And to avoid this confusion, we must indicate the name, the number of the witness in whose evidence this real evidence has been tendered. This is more important in criminal cases than in civil cases. There is another set of documents which come up for exhibiting, and those are ones which are put in cross-examination. Documents to be confronted in cross-examination need not be filed earlier. They can be produced for the first time, even at the stage of cross-examination, but to indicate that this is a document with which a witness has been confronted, there is a different way of exhibiting, and that is PW1 over D1 or DW1 over P1. If it is D1, then it is a document of defendant which has been put to the plaintiff, and if it is P1, then it is the plaintiff who has put a document to defendant in cross-examination. Therefore, merely from looking at the exhibit, one can make out whose document it is and who has exhibited and who has confronted the person with the document. This I would conclude by saying, again, repeating and emphasizing that merely putting an exhibit on a mark is not an evidence, and it is not to be confused by proof of a document. It is only that particular document which has been exhibited, which means that no further formal proof of that document would be required. The easiest and the simplest example to explain this is, a registered will may be exhibited, but if the will is in question, merely by exhibiting a registered will, the onus will not get discharged, as it is also required to be proved by a witness. Unless a witness also is examined, merely by putting an exhibit on will would not make it a proof document in the trial. And this is what has been held in various cases. Now, the most difficult part which comes in is the objections we have seen when we are doing it in the court. To every second document, there is an objection. How are we deal with those objections? In Bipin Shantilal, it was said that whatever be the objection, it must be recorded. It must be recorded and be left to be decided at the stage of final arguments. There were 2-3 reasons given in this judgment as to why objection need not be decided there and then. The first was that if the objection is left open, the appellate court would have the benefit of having that evidence, and they can reconsider whether that evidence or the document needs to be considered or not. If the objection is decided there and then, and the document is not allowed to be brought on record, there is valuable evidence which is not being taken on record, and the chances of case getting remanded back increases. There was another practical reason why in this case it's a full bench judge of the Supreme Court. They said that if we decide an objection every time, there is a tendency to go in revision, challenging the finding of on the objection, and this can derail the whole trial. It is not required. We may note the objection, which may be taken up at the stage of final arguments. This also gives you and preserves your right of challenging it in appeal. Then came this case of Venkatachala, where again the same question came up, and it said that no, the question of inadmissibility of a document must be decided there and then. It may look there is an apparent contradiction between the two cases, but no. What the judgment says is that when the objection taken goes to the root of the document, it goes to the validity of a document, then it must be decided there and then, and such document must not be allowed to be taken on record. However, if the objection does not dispute the admissibility of a document, but is directed towards it being merely irregular and insufficient, then it can be deferred for the subsequent stage. And this has been better explained in the case of Geeta Marine Services. This is a Bombay High Court judgment wherein they have said that an objection raised regarding the proof of document or insufficiency of proof has to be dealt with immediately, but if it goes to the legality, then it can be deferred. A simple example is that if there is a photocopy being produced and it is not objected to, then it is the mode of proof which is being questioned and it will be deemed to be exhibited. But suppose a photocopy is objected to, it gives an opportunity to that person to then bring in an original and an opportunity to bring on record the best evidence. And therefore, mode of proof is what needs to be decided, but where the legality of the evidence is concerned, that may be deferred. Now, in this context, there is one question which is extremely, which keeps cropping up, and that is if insufficiency of the stamp duty. Once a document is tendered which is not sufficiently stamped, it is the obligation on the court to impound the document and impose the penalty. However, if it is overlooked and the document is exhibited, it becomes admissible by virtue of Section 36. Once an insufficiently stamped document is exhibited, then it cannot be challenged again and it can be read in evidence. Now this is where the Courtcraft comes in. How should you take an objection? You imagine a court scene. What goes on in the court? It is hectic, overcrowded. Many people are speaking at the same time. There's a lot of impatience. Everybody is in a hurry. And the person who has to tender the evidence or whose case is being taken up has a lot of anxiety. In this kind of chaos, I remember in one of the sessions it was said that it is almost like a theater where every person is actor. And in this scenario, each advocate and the party who's appearing for evidence are part of this drama. Everybody has a role to play, and how well you are able to conduct yourself and to control your behavior is something which is extremely important in helping you to be able to get through what you intend to. Now, there are three aspects for raising an objection. What is the correct procedure? Whether a raising of objection is taken as a tactic, and third is how do you respond to the objections? The objections must be taken at the right time. When I say it has to be taken at the right time, it means that if it is being raised subsequent, suppose a photocopy has been exhibited, if at the end of the day or on a subsequent day you want to raise an objection, it will not be acceptable. Objection has to be taken at times to the questions that are being put in the oral evidence. At times the question itself is objectionable, at times the answer is objectionable. It will depend upon the situation, but if a question was objectionable and an answer has already been given, then it is too late to object because the evidence has already come. You may strike it down, but whatever the harm or the damage was to be done is already done. Suppose there is a question on character that is put. Character evidence is not admissible, but if an answer is already there, that he is a man who has been convicted, or he is a man who has already divorced, or such like admission, the evidence, the truth is already in the knowledge of all who are present. And therefore, objection has to be taken timely. Objection taken late would defeat the whole purpose of raising an objection. The second is it has to be specific and precise. Now, what I mean by specific and precise, I'll tell a little later. But when you have to raise an objection, how should you do it? It's a very common situation in the courts that whenever a document is tendered or whenever a statement is made, immediately comes the opposition objection. Now, why is it being objected to is never explained. And neither the court can understand nor the party can understand as to why an objection to a statement is being made. So, merely by saying objected to will not be of any use or effect. I have seen so many times, be it civil trial or criminal trial, every second sentence gets objected to. And how do we proceed further? We keep writing objected to and keep moving further. Does that recording of objected to without any basis help us? That is a question we'll discuss later. When an objection is taken, you should be in a position to explain why an objection has been taken. Please listen carefully to the questions that are being asked, answer patiently, and this is where you would be able to carry your motion. Now, objections can be of two kinds. They can be to oral evidence. What are those? These are the legal objections: hearsay evidence, character evidence, irrelevant, opinion evidence. Whenever a witness is giving an opinion, which is giving an hearsay evidence, it has to be objected to there and then. But even if it is not objected to, being a legal objection, there is the court may even otherwise, even if not objected to, might reject it at the stage of final decision. Now, where documents are being exhibited, the legal objections are: it is the secondary evidence for which no foundation has been laid. It has not been shown as to why secondary evidence should be permitted for a particular piece of evidence. The photocopy, that is largely the mode of proof. If objection not taken at the right time, then this objection cannot be taken subsequently. As I said, there can be a lot of technical objections. Why? What are these technical? Questioners leading. I think it's a very common objection, which is very frequently taken in the courts. It is speculative. It is compound. Now, when I say it is compound and ambiguous, it is very interesting, because we say you went to the market and you met the accused. Now, there are two questions which have been put together. You may have met the accused, but it may not be the market. If you say only yes or no, it becomes an ambiguous question, because one part had to be no, the other part had to be yes. Now, what has happened with the yes and no? Incorrect evidence gets recorded. Generally, don't put ambiguous or compound questions, and if such questions are put, you must raise an objection of it being a compound and an ambiguous question which needs to be reframed. Many a times, the questions that are put in testimony are argumentative, and that is, how can you sit here and lie to the court about your attitude towards the victim? This is being argumentative. What is recorded in the evidence is only the facts and not the arguments, and such like questions must be necessarily objected to. A hypothetical question: suppose if you were there in the position, how would you have behaved? This is a purely hypothetical question which cannot be permitted, to which an objection must be taken. There are times when the witness avoids an answer, like you said, did you see the person at the time of death? And the answer comes, I had nothing to do with that. And these are the times when you need to object, you need to elicit the complete and the correct answers. Now, there can be an objection to the way the questions have been formulated, which we have already discussed about. Now, another very, very interesting aspect is that many a times objections are used not because they are genuinely required to be raised, but also because it is a strategy, a tactic for good trial. You must raise an objection, but when? Only when it hurts your case or you need to protect your witness. It is a common scene in the courts where the questions are put to the witness to an extent that they get so harassed that they give up giving the correct answers. Many a times they end up saying, I have nothing more to say. And this is where the witness needs protection, where the way of questioning and the objection being raised needs to be objected to by the other party. But it is not a good practice to raise objection every time and for everything. Don't object if it would only highlight a weakness of your case. In any case, if it is to be admitted, what is the point of raising an objection? And it may even open the door to other evidence. Suppose in a case of maintenance, questions are put in regard to the previous marriage. This is not relevant. But if this kind of question is permitted and no objection is taken, what happens is an whole Pandora box for the cross-examination is opened. Once the chief has been permitted, objection cannot be taken to cross-examination on those aspects. There are many a times when there are tactics which are used, applied, but are they ethical all the time? Many a times, and I think all of us have experienced this, that the objections are raised time and again to everything, not because they are genuine, but because you want to disrupt the witness or to frazzle the lawyer. And many a times this has happened that you get so enraged that you forget to answer the questions correctly or you miss out on the important questions or important facts. They get missed out because the opposite counsel has been able to ruffle you by raising unnecessary, incessant objections. This kind of practice is not ethical. But then it is all a part of courtcraft. It is for you to decide whether you should indulge in this kind of raising of objections or not. There's another very interesting drama which goes on in the court, which is prompting. Now, what does happen? What did you see next? I saw a blue car driven by what looked like defendant. Immediately comes the objection. Irrelevant and prejudicial because it has already been established that defendant was at home with his mother and he could not have been driving the defendant's car. Now, what has happened? There is some evidence saying that he was present at home, but what is the counsel trying to do? Bring out from the testimony of another witness that no, you are seen driving a car. But this kind of prompting warns the witness and prevents the correct evidence to come on record. This kind of leading an objection can at times be not well accepted. Now, there is this another very interesting example which happens day in and day out. The question is, you were 60 feet away. Yes. It was 12 midnight. Yes. There was no moon, no street light. Yes. Now what is happening? The witness does not know where these questions are going to lead, but the lawyer has understood. So immediately, what comes? It is a trick to insinuate that witness that he could not see. And there is enough hint, enough prompting for the witness who has become smart by now. And what is the answer? No, there was no moonlight or street light, but I could see the face of the accused clearly. This kind of prompting and raising objections is again maybe a part of courtcraft, but not a good practice as we can see. It is why I say it is not a good practice, because the court, the judge who is seeing, who is conducting, who is part of the recording of evidence has been observing the conduct. And what happens is that there are lots of discretions with the court. The court would not exercise the discretion in your favor because of your unethical practices at the time of recording of evidence. So don't raise frivolous objections. Did you see the defendant come into the room? It's a leading question. What happened next? Dependent came in. So what you have objected to would in any case come in through another question. Don't raise these kind of frivolous objections, because if you have raised too many frivolous objections, then even if you raise a genuine objection, it is bound to be overruled. Now, what is the best way of then doing it? I'll give you one example. There is this witness who comes on special power of attorney, and when the power of attorney is being exhibited, at that stage only there is a huge objection that he is not a competent witness because he does not know anything, and as an SPA he cannot object. But rather than objecting at the stage of examination in chief, the better would be to demolish him in the cross examination. 4 questions. You have no personal knowledge. You are based only on the document. You were not in the employment are enough to shake his credibility. Things which can be done more appropriately by way of cross examination must be done in a legal way rather than going into these kind of frivolous objections at the time of tendering of evidence or the objects. I would end by saying that raise objections, but only when it impacts your case. Admitted documents, evidence need not be objected. Establish harmony, establish goodwill, establish cordial atmosphere, establish your credibility, and that is what will last you in the long run. Thank you very much. I think whatever little I had to say, I have said it, and now I'm open to any kind of questions. Thank you. Over to Shreya.
It was a detailed and a very clear presentation. I had my own simple revision with you, and it was very good. Thank you so much. And ma'am, we'll take the questions. There's Advocate Himanshu Jain. He has raised the question that every document obtained immaterial to the mode of obtaining, relevant for the facts of the case. But the same is not the case of electronic evidence, even put in the same chapter.
You are right. You are right. I missed out on the electronic evidence because electronic. I think there has been a lot of confusion since we have started accepting, because the fundamental rule is that every kind of electronic evidence has to be supported by a certificate under Section 65B. Now, what is the validity of a certificate of 65B? There are certain requirements. Now, lately, what I have noticed is that whether it is a computer generated photograph, SMSs, CDs, your mobile phones, what is happening when it is being tendered as a document, that is done at the time of pleadings or at the stage of when the affidavit is filed. The copies are placed, but 65B certificate they bring at the time of actual tendering of affidavit, which is absolutely incorrect. It has to be simultaneous to taking out the print. If you have taken out a printout today, then the 65B also has to be dated of the same day. Because in between what has happened, 15 days, 1 month, 6 months, the computer may have been tinkered, it may have been tampered, it will not be contemporaneous. And this is a new practice which I've seen recently. The 65B certificates are not filed along with the document, but they are filed subsequently, which is not right. That way, even if you file your 65B, it is not valid proving of document. Now, when we are talking of electronic evidence, there have been many issues, because when it is SMSs, when there are WhatsApp chat, now who is to furnish the 65B? Essentially, anybody who's taking out a printout can do it. Now, there is also a trend that when, even if the 65B is not there, it is a document which is admitted, especially in matrimonial cases, in contracts, there is heavy reliance on these emails exchanges. If the party is admitting an email is sent to you, I think we can dispense with 65B, and we can take it as a bid document. It may be read. But still, there is a lot of fluidity on this aspect. There is no clarity. Insistence is on 65B, which should be filed every time there is an electronic document which is placed on record.
There's another question. by Advocate Tejasvi Goyal. At the stage of ex parte evidence, plaintiff is unable to provide original documents, and instead of those, he brings the photocopy of those documents. So, in that situation, one needs to mark those documents as Mark 1. The question continues is another. So, those documents are marked or exhibit. If it needs to be marked as mark, then why? Because in this situation, there is no other party who disputes the same during recording of evidence.
Yeah, again, a very, very important aspect because there are two views on it. When
Right.
there is other party is not present to object to the mode of proof, because when you're producing a photocopy, it is only a mode of proof which is being questioned. If there is other party not present and not objecting, then essentially these documents should be exhibited and should be relied upon. But there is another aspect to it. The burden of proving a case never shifts. It is only the onus which keeps shifting from one party to the other. Burden always remains on the plaintiff. The burden is on the plaintiff and the rule of producing best evidence. Like if it is a photograph, even if the negative is not there, maybe it can be accepted. But suppose there may be certain documents which go to the legality. So producing a photocopy may not be enough. But if it is only like a rent deed which is being produced and it seems to be genuine, I think there should not be an objection to exhibiting it. But yes, if it goes to the legality, then maybe the best evidence, which is the original document, that has to be produced.
Mhm. And there's another question by Advocate Yogesh Bhardwaj. Is it mandatory to exhibit the documents before the court? Sometimes we see in 138 cases that documents are already exhibited at the time of filing. And I think his question
I
also continues. So he says in 138 case, can we exhibit the notice without supporting the certificate of 65B Evidence Act?
If it is computer generated, then there should be a 65B because this is not on mode, but it is on the legality of a document itself. It should have a 65B. And when you are saying that you are exhibiting documents at the stage of filing of the complaint, that is because you are also filing a pre-summoning affidavit of evidence. So
Hardly.
documents are not being exhibited in the petition, but they are being exhibited in the affidavit, which accompanies the complaint under 138.
Ma'am, there's another question by Advocate Akshay Sharma. Please enlighten as to what are the hazards in recording of evidence statement by way of appointing court commissioner, as been frequently been done in the recent past.
Yeah, this is a moot point because personally, if you were to ask me, I'm not very happy with the evidence being recorded by the court commissioner, largely because the conduct and the way the parties appear in the court also gives you an insight. There was a time when demeanor was a very important component of recording of evidence. Now, when there is an evidence being done by the court commissioner, then this very important aspect of actually monitoring and seeing how the evidence is being tendered gets lost. But on the other hand, recording of evidence by the local commissioner, by and large, ensures that there is some expediency, there is a little less delay. The courts are overburdened when the evidence gets recorded. A lot of burden goes off the shoulders of the court. But what I see is that when the evidence is being recorded before the commissioner, he has very little powers to control the evidence. So whatever is being said, he has no option to but to go on recording it. So there may be certain parts which maybe the court would not have allowed, but would come on record. As I was saying, there may be some frivolous evidence which comes in. If there is frivolous evidence which has come in, then obviously the cross-examination would also be there. So when the evidence is being recorded before the local commissioner, it goes a little beyond what is required. And second thing is, they don't have the power to decide the objections. So whenever there is something done, you have no choice but to just go on recording. There is an objection, and what is the objection? Now, when I said that objection must be taken at the right time, harm is already done. If we have already recorded whatever was to be recorded, then the harm is already done. There are certain facts which should not have been on record. It is already there. Whether we are all human beings, whether we, no matter how much we say, it will not make any difference, but we do get impacted with certain facts which may not be material or relevant, but have come on record. So I personally feel that it's just a matter of convenience that we are going more into evidence by local commissioners.
Ma'am, another question. Unregistered sale deed marked without objection. Is that document, can the document be considered valid?
Simple answer. Registration Act says such document is not admissible in evidence. Once the Registration Act itself says cannot be looked into, and please read the connected with this, that any sale deed is creating an interest in the property which is more than rupees 100, and there cannot be any transfer unless it is through a registered document. There is no stamp duty. That I think Suraj Lamb's case of 2010, I think, my Supreme Court of India has very clearly said that such like sale deeds, if not registered, are nothing but then a piece of paper.
Ma'am, another question by Advocate Hilal Manzoor, that can one withdraw his examination in chief affidavit after filing? If not, can he file the second affidavit to clear the mistakes mentioned in the prior one?
Now, let's take an analogy with what happens in the court. You have given a statement. Now you want to give additional evidence. Simple thing is move an application saying I may be permitted to tender my additional evidence. So if you want to give an additional affidavit, you will have to seek permission from the court by way of an application saying that I may be permitted. And look, what has come on record, it is under your signatures, it will be on record. Even if you are retracting, it will be a retracted evidence. An affidavit is a statement on oath and it can always be read. You may correct it. It may amount to contradiction. It may amount to improvement. It may be relied on. The evidentiary value is something which will be assessed by the court at the time of final arguments. But additional affidavits, yes, by way of additional evidence.
Another query by Advocate Satyendra, who's saying, can certified copy of another court file be exhibited without summoning the original file?
Yeah, that's the point I was making, that the pleadings are all private documents. So to exhibit a certified copy of a pleading, technically the court file would be required, but this can be dispensed with if the other party is not objecting to it. Evidence and the judgment, these are two documents which are created by the court. They are under the signatures of the court and therefore they are public document and per se admissible and you can exhibit them, but not the pleadings, unless, of course, the other party agrees.
Another question by Advocate Amit Manocha. Many times, banker is summoned to produce the bank records, but 65B submitted by bank witness is not as per format and is objected by the cross-examining counsel. To what extent the same is admissible?
Of course, it is admissible because that's what I was saying. 65B has a purpose. It says that the computer was within my control. It has not been tampered. So if the 65B certificate is not accurate, it impacts the evidence itself. But the remedy here is get it deferred and bring in another 65B along with the printout. See, you should correct it there and then, and that is the purpose of raising an objection. If you don't raise an objection, but this being legal objection, irrespective, it will make your document inadmissible.
Another query of Advocate Vikram Singh, that if photocopy is exhibited, can the witness be cross-examined up to the extent of photocopies and no original document shown to prove the discredibility of the photocopies, and what would be its effect?
Yeah. Once a photocopy has been exhibited without objection, it becomes valid evidence. And therefore, you can and you should do full cross-examination on that photocopy because it has now become admissible as the objection was not taken.
Another by Advocate Gaurav Kohli. Does CCTV recording too need 65B certificate if original recorder of CCTV is with bank, etc.?
No, it's with the bank, not with the court. It has to be produced in the court to become a first original document. If there is something contained in the computer, then you will have to tender the computer as the primary evidence, or else you bring the 65B. Generally, these CCTV cameras, CDs are being prepared. CD becomes secondary. For that, you will require a 65B. Or you bring the recorder, the whole thing itself in the court, which is actually not feasible.
Ma'am, what is the evidentiary value of marked documents, whether they would be read in evidence?
See, that's what. If the marked document is a photocopy to which an objection has been taken, then it cannot be read. If it is a, see, I'll give you a very good example what happened with me. There was this original letter produced by the plaintiff. Original letter which he was claiming was written by the defendant. An objection was taken and it was marked. Though it was an original document, and I did say at the stage of final argument that even if it has been marked, it's an original document, I should be able to look into it. And the answer was, if you have marked, you have already recorded, it shall not be read in evidence unless proved otherwise. You have deprived me of the right of proving it or putting a cross-examination. So if it is a marked document and objected to, then it has to be proved.
Ma'am, another query by Advocate Nirmal Bhalla, that in a matrimonial case, if documents filed by the wife not objected by the opposite counsel in family court, can opposite counsel take the objection on the same documents in Mahila court?
Yes, these are independent courts, independent proceedings.
Procedure.
Every court has its own procedure.
Another question by Advocate Ruchi Kurana. Whether is it all right to cross-examine the official witness who has been summoned only for producing documents? I've seen tendency of some lawyers to do that.
You are right. There is a distinction. There is a witness who is a witness of record. If he is a witness of record, he can only produce a record. He cannot be questioned on the contents because he is not a privy or a party to it. The document, the contents have to be proved by the concerned person. But here, again, a word of caution, if it is a public document, then per se, its contents become admissible. Suppose it is some MCD record which is produced. It is a Kasra, Khatoni, it's a public document, and therefore merely proving a document will automatically prove the content. There's no point cross-examining the record witness.
Another question by Gaurav Kohli. What about clause force majeure inserted in rent agreement? Will it be allowed as no law, no provision for force majeure? The question.
See, this is on the interpretation of a document. If it is a contract in a rent agreement where you have said, you have visualized a situation that in case of force majeure, no rent would be payable. It's the content of a document which has to be interpreted. It is the term of a contract which you will have to see the whole contract to see whether a clause of force majeure in a rent agreement is a valid clause. Whatever will be its legality would be seen at the time of finally deciding the case.
Ma'am, another question by Advocate Chandar Bhardwaj. How objection regarding legality of documents is decided by the court at the stage of arguments?
Yeah, that is what is decided at this stage. See, it's a very simple example because it keeps coming. The will. If it is a registered will, it has to be exhibited, but it does not get proved. So how would the court, there's no need. I cannot take an objection to exhibiting of a registered document. It has to be necessarily exhibited. But is it proving that this is a will by which I have received the property? That's a legal question which will be decided only at the stage of final arguments or final judgment, whether this document is sufficient to prove that the property has devolved upon. That's how you decide it at the final arguments.
Ma'am, there's an observation. This is written by this advocate Vikas Yadav quite many times. In my experience, filing of 65B Evidence Act affidavits are allowed by the courts at later stage also. And then,
That's what I'm saying.
yeah, and then is there any judgment that same cannot be allowed? So I think you need to research.
No, this is the point I was making, that you read Section 65B and you yourself we fall upon the judgments later. There are judgments to this effect, but I'll have to look up. I've not looked up on that aspect, and it has to be. And that is what I was saying, that recently, as my DJ tenure, I've been noticing 65B certificates being tendered later, which according to me is not the correct procedure. But I think if you want an answer, I'll look up, because I didn't prepare myself on that. There are judgments which say it has to be simultaneous to taking the printout of the document.
Ma'am, there's another request of kindly share the PPT with us. So the one advocate
Please
has,
share it.
ma'am, you
Okay, I'll just I'll share it with you and you can mail it to everybody.
yes, ma'am. We all have WhatsApp group, so we'll be, ma'am. We finally conclude the question answers. This is the session where we have had maximum number of questions, and the patience you've had in answering all of those is commendable, ma'am. Thank you so much. I would just open my member secretary.
Thank you.
So, sir is also
Indeed, my
joining us.
pleasure, and many thanks to Kamalji. Thank you so much, and Shriya. She's been struggling with me for last 2 days, to get me set up on this.
Yeah,
And
I
of course,
understand.
all the
She
secretaries
told
of the
me,
district.
definitely, she told me, she apprised me of this fact that she had been doing that thing with you, that trial practices and all that. And as she has said, the
Right.
amount of and the number of questions, I was there, I was watching throughout. The number of questions which have been generated in this session in itself shows the tremendous interest which you have generated in all the lawyers. And it was really very clearly, very aptly, and very simply you have stated the differences, that how a document is to be marked, and if marked, how the mark number should be given, witness wise, and in case it is during the course of cross examination, how it is to be exhibited, now whether exhibited document dispenses with the formal proof of the document. So everything has been tremendously explained. Then you have explained about Courtcraft, that whether the witness is to be disrupted, what sort of objections are to be raised, and all that. Really tremendous. I am really very thankful to you for the effort which you have put in. और इतने stern और elaborate session के बाद to make the moment light, मैं एक incident सुनाना चाहता हूँ on cross examination for the benefit of all my panel lawyers. I need to tell them that Neena ji and myself, we are from the same batch. हमने 1992 में जब ज्वाइन किया, उसके बाद हमारा कोर्ट में अटैचमेंट रही अलग अलग. One of our batchmates, he got attached with additional rent controller. At that time, Justice he was additional rent controller. उनके साथ attachment थी. So at that time, a petition of bona fide requirement that was pending and that was being tried by that court. और cross examination चल रहा था of the landlord who had filed that petition of bona fide requirement for getting back his tenant. The tenant का lawyer was cross examining the landlord. तो cross examination में ऐसा कहा होगा कि इतनी मेरे पास accommodation है, I have these many family members, so for my requirement I require this premises. Tenant के बारे में पूछा कि आपके घर में कौन कौन है, आपकी accommodation कितनी है. फिर the next question was कि आपकी बीवी आपके साथ रहती है. Witness then retaliated और कहता है कि वो तेरी किसी original रंजीती. So that sort of questions disrupt the witness and definitely you will उसके बाद से ऐसे responses आप जनरेट करोगे अपने लिए भी. That was on a lighter note. Thank you again so much and the efforts which you had put in, and a special thank you for acknowledging the work which we are doing. You have acknowledged our work also, and I'm telling you that it is not my individual effort. I have a dedicated team of my secretaries and all these panel lawyers. They are part and parcel of our team. It is because of their hard work that we are in a position to earn such name that okay, we are doing. Or you are well aware that during this period of COVID-19, as per the directions of Honorable Supreme Court, so far as decongestion of jails is concerned, these people, these lawyers of ours, they are doing tremendous job. They are visiting the jails, they are drafting bail applications, and they are moving the same in courts. So I'm really very thankful, and I'm very proud of them, of the hard work put in by them. And thank you, Neena, for acknowledging
Thank
our
you.
efforts. Thank you so much.
Thank you so much. Just one word, the lawyers that are working in DLSA have increased our work in the districts, They are making the work.
Wow. Ma'am, that's indeed a compliment for all of us.
Absolutely, absolutely.
No, ma'am, we tell our member secretary that earlier we used to work 10 to 5. Now we are actually working 10 to 10.
Yes,
We're not even 10 to
exactly.
10. At times, you're working 10 to 12.
By 7. I know. I know.
That's great, ma'am. Thank you so much, ma'am. Thank you, Ms. Sir. We will
Thank you.
conclude now. Thank you.